Welcome viewers to your own channel Kanooni Charcha. Today again I am with the new judgment of Supreme Court of India. I will discuss it in this episode. It is dated 29th of August 2024. A division bench of Supreme Court of India consisting of Justice Bela M. Trivedi and Justice Satish Chandra Sharma has delivered it. It is in a special leave petition. Special leave petition was filed against the order of Hon'ble High Court of Madras. This para 2 is containing, you may say, is containing the how against which order this SLP was filed and what are some details about the earlier order passed by the High Court, and it was a revision before the Hon'ble High Court of Madras against the order of the Court of Session. Court of Session has rejected an application filed before him for alteration of charge, for modification of the charge. I will go to the details afterwards. First, I will read out the para 2. The instant appeal filed by the appellant de facto complainant arises out of an extremely unusual and untable judgment and order dated 27th of July 2017 passed by the High Court of Judicature at Madras in criminal revision, being, this is number referred here, and whereby the High Court, by allowing the said revision application, set aside the order dated 18th of October 2016 passed by the Principal Session Judge Dharmapuri, framing charges in SC 19 of 2015 and directed the further investigation in crime number 2074 of year 2009 under section 173 subsection 8 of Code of Criminal Procedure. Virtually, I have already referred here verbally that Hon'ble High Court of Madras was hearing this revision petition against the order of rejection of application for modification, alteration of the charge by the Court of Session, and Hon'ble High Court has ordered the further investigation by allowing the revision petition. Then I will refer in very detail the brief facts of the case. It was a case of stabbing. Made by accused number 1 and 2. One caught hold of the deceased and other stabbed with a knife. There was also infliction of injuries by this is iron rod. This is reference. The deceased died, and the offences for which the FIR initially registered is 147, 148, 323, 324, 307 and 302 of Indian Penal Code. Virtually, it is a murder case now. After investigation of this case FIR, a charge sheet was filed before a Court of Session. The accused of this case was 31. The charge sheet was against accused having number 31. What happens in the start? The respondent number 2 filed an application prior to framing of charge for discharging him from the commission offence as alleged against him, obviously in the police charge sheet. This application of him was rejected by the court of this session. After that, he went in revision before the Hon'ble High Court of Madras. His revision petition was dismissed. Afterwards, case came back and formal charge was framed against all the accused. Again, attempt was made. This is detailed in para 6 by filing an application for alteration of the charge this time, for modification of the charge framed. This is earlier an application was filed by the respondent number 2 for discharging him in terms of section 227 of Code of Criminal Procedure. This time he invoked section 216 of Code of Criminal Procedure for alteration, modification of the charge framed against him, and other also joined him. But this application was also dismissed. Now, the respondent number 2, who was accused number 2, he again filed the revision petition before the Hon'ble High Court. This time against the order of dismissal or rejection of his application for alteration of charge. This time I have already read out the para 1. The High Court allowed his discharged, and the case was remanded back for further investigation in terms of this 173 subsection 8 of Code of Criminal Procedure. Against this, present SLP was filed. Now, these are the facts and of the case. Now what are the observations? What are the findings with regard to this section, this 397, scope of section 397 of Code of Revision Petition? So generally, it is referred that order of alteration, modification of charge is an interlocutory order, and against interlocutory order, a revision petition is not maintainable. This is they have taken assistance of one judgment of the earlier judgment of the Supreme Court of India. It is contained in para 9 of this judgment. I will read out this. At this juncture, it would be apt to refer to the observation made by this court in Amit Kapoor versus Ramesh Chandra and another. So while discussing this, but is a scope of 397 by the order passed, alteration, modification of the is an interlocutory order. The para 12 and 13 of Amit Kapoor and Ramesh Chandra and other judgments are referred here. This para 12 of judgment of Amit Kapoor, which is referred here. Section 397 Code of Criminal Procedure vests the court with the power to call for the examine and record of inferior court for the purpose of satisfying itself as to illegality and irregularity. This is what are the provisions of section 399, what are the requirements, what are the powers under which scope of the section 397 is contained in para. Now para 13, this is also another well accepted norm is that revisional jurisdiction of higher court is a very limited one and cannot be exercised in a routine manner. This is what is the scope of the section 399 7 of Code of the Criminal Procedure. It is referred in para 12 of this judgment, Amit Kapoor judgment, and para 13. What is the scope of this? This is also with regard to then adopting this adopting the principle as envisaged in this judgment, Amit Kapoor, the Honorable Supreme Court observed in para 10. Thus, the scope of interference and exercise of jurisdiction under section 397 is extremely limited. Now they have interpreted the judgment of Amit Kapoor. And further mentioned that subsection 2 of section 397 prohibits the court from exercising power of revision. Even the power under subsection 1 thereof should be exercised very sparingly and only when the seizure under challenge is grossly erroneous or other there is a non-compliance of provisions of law or the finding recorded by the trial court is based on no evidence or material evidence is ignored or judicial discretion is exercised arbitrarily, perversely by framing the charge. This court exercising revisional jurisdiction under section 397 should be extremely circumspect. This is not this court, but the court concerned, which is exercising a revisional jurisdiction, must be careful what is scope, what is ambit of section 397. Now I will go to para 11. It is tried to say that section 216 is an enabling provision which enables the court to alter or add to any charge at any time before the judgment is pronounced. And if any alteration or addition to a charge is made, the court has to follow the procedure as contained therein. Section 216 does not give any right to the accused to file a fresh application seeking a discharge after charge is framed by the court, more particularly when his application seeking discharge under section 227 has already been dismissed. Unfortunately, such applications are being filed in a trial court sometimes in ignorance of law and sometimes deliberately to delay the proceeding. This is an observation of the Supreme Court of India with regard to scope of section 216. I will delve upon and section 227 of Code of Criminal Procedure. Once such application, though untenable or filed, the trial courts have no alternative but to decide them, and then again such order would be challenged before the High Court, and the whole criminal trial would get derailed. Suffice to say that such practice is highly deplorable, and if followed, would be dealt with sternly by the courts. But this section, scope of section 227 is different, and section 216 of Code of Criminal is different, because one deals with this discharge of the accused. An accused can approach the court, the trial court, at the time of framing of the charge, or even prior to that, for discharging him whatever the charges are against him in a police charge sheet. The section 216 of Code of Criminal Procedure having different scope. It has a different field to be played. It is regarding to alteration of the modification of the charge, which is already framed. These two sections cannot be overlapped. These are two independent sections, and scope of these two sections are, once in present case, the Honorable Supreme Court of India, as they have observed. I have studied this judgment, and now I am going to When discharge application, prayer for discharge has been dismissed and order upheld by the High Court in the earlier round of litigation. This is the observation made by the Supreme Court of India. This judgment I am telling you verbally. Again, an attempt is made for another way by using the provisions of 216 for modification and alteration of how it is. Then order has been remains intact, order of framing of charge. How it would be a new application. This sessions court have dismissed this alteration application, modification application also. Now I will go what about the crux of the so far as this is para 12. So far as the facts of the present case are concerned, as stated herein above, the respondent number 2 has miserably failed to get himself discharged from the case, which I have already verbally and this mentioned, had miserably failed to get himself discharged from the case in the first round of litigation, when he had filed the application under section 227 Code of Criminal Procedure. Still, however, he filed another vexatious application. Now, the second application, the Hon'ble Supreme Court has observed it is a vexatious application. It is not filed in good faith and has derailed the criminal proceedings in this case. The said application also having been dismissed by the Sessions Court, the order was challenged before the Hon'ble High Court, but I am reporting up against with this SLP which we are discussing. Filing revision application under 397 of Code of Criminal Procedure. High Court on an absolutely, this is observation of the Hon'ble Supreme Court. The language seems to be, they are very serious with regard to the order passed by the Hon'ble High Court in this in the second round of revision. The second revision, which is against the alteration, modification of the charge. Now I will read out what the Supreme Court has, our Supreme Court has observed. High Court on an absolutely extraneous consideration and in utter disregard of the settled legal position, allowed the revision application filed by the respondent number 2, though legally untenable. Again, this word is good, and set aside the charge framed by the. But by allowing the revision petition by the Hon'ble Court, second the revision made against alteration and modification. I am again repeating, and this is that it was against alteration. What happened? That he was discharged and set aside the charge framed by the Session Court against the respondent with the order of framing of charge. The charges framed was earlier assailed and order remained intact. I have again, I will. The said order being especially illegal, untenable, and devours the material under guard, and seems deserves to be order of the Hon'ble, which is impugned in this this SLP, this special petition, with regard to this this order of the Hon'ble. These are the observations made by the now para 13, which is a crux of the that in view of the matter, impugned order set aside, the order of the High Court for ordering further investigation in the matter, and order of discharge of the accused number 2 was set aside by the Hon'ble Supreme Court in this SLP. The order passed by the Session Court is restored, order of framing of charge. The respondent number 2, accused number 2, having sufficiently derailed the proceedings by filing frivolous and untenable application, one after the other, misusing the process. The present appeal is allowed, this SLP allowed, with the cost of 50,000 payable by the accused number 2 by the respondent number 2. Within 2 weeks time was granted him to pay, the respondent who shall first deposit the cost in office of this court, this shall be permitted to be withdrawn by the appellant. This cost which was imposed, the appellant was allowed to withdraw the scrap. He was found entitled to that. The session court is now directed. This is the very, again, para 14 you will read. I am going to read. The sessions court is directed to proceed further with the trial against all the accused, including respondent number 2, by whom alone the revision petition was filed and whose revision petition was allowed, and which order of allowing the revision petition is now assailed in this SLP in accordance with law and as expeditiously as possible. All the parties are directed to cooperate the trial court to conclude the trial as expeditiously as possible. Further directed that non-cooperation of any accused in proceeding with the trial shall entail cancellation of their bail. Whosoever was found was on bail, the appeal stand allowed and with cost as directed, the office shall ensure compliance of order, payment of cost by the respondent number 2, and to report in case of non-compliance. This is the order. What happened? The case is of year 2009, and this order is 2024. 15 years time. 15 years time after the occurrence, the FIR was registered, and this occurrence took place in the year 2009, and now it is a month of August, 29th August 2024. Now case will go back. 15 years delay has been caused by this respondent number 2, and who was accused number 2 by according to Supreme Court as of by filing frivolous application, and delay has been caused. Now Supreme Court has made a direction to the trial court to expedite the matter and decide this police charge sheet, the expedition. This is today's how the mockery of the procedure, process, and practice is made, and which has led to travesty of the justice in the present case. Now I have found this judgment, and I thought that our judges who frame charge, obviously when order is of framing of charge has attained finality, how the alteration application would have and which has virtually resulted into discharge of that. This is detail I have found. I have discussed with you. Please, this is sufficient for today. Again, I will join you with new episode, with having new topic, new episode. Thank you very much.